recording, letting IT know we can start. Asking your friends to turn their videos on. I am waiting for Ms. Dixon to start her video. Ms. Dixon, if you could please start your video. Thank you very much. Oh yay, oh yay, oh yay. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-5341. MediNatura Inc. Appellant versus Food and Drug Administration et al. Mr. Sammons for the appellant, Ms. Dixon for the appellees.
Mr. Sammons, good morning. Before you start, we've had some difficulties with our connections. Judge, well, there he is. Okay. Judge Wilkins can hear, but we can't get him on the video, but it looked like we did for just a second. So if you would proceed with your argument.
Thank you, Your Honor, and may it please the court. I'm David Salmons on behalf of MediNatura. This appeal from the denial of a preliminary injunction concerns FDA's recent dramatic change in policy governing the importation and marketing of homeopathic drugs. Before turning specifically to the court's question about the Cook case, I'd like to focus for a short moment on the nature of this policy change, which I think helps answer the court's question. For decades, CPG 400 made clear that homeopathic drugs that reflected recognized or customary homeopathic practices and complied with manufacturing and labeling requirements specified in the guidance may be marketed in the US without first going through a new drug application process. Remember that applications are only required for new drugs, which are defined by statute as ones not generally recognized as safe and effective by qualified experts, sometimes referred to as the GRAS-E standard. Remember also that FDA's position for decades was that its existing GRAS-E protocols were developed for pharmaceutical drugs and were poorly suited for the uniqueness of homeopathic medicine. So FDA indicated it would eventually develop a homeopathic specific protocol for determining new drug status. In the meantime, 400 effectively treated homeopathic drugs that complied with its standards as if they were not new drugs, but were instead at least potentially generally accepted as safe and effective. Now, through its withdrawal of 400 and its import alert, FDA seeks not only to impose the existing GRAS-E process on traditional homeopathic drugs for the first time, but to suddenly declare unsafe and block from importation any homeopathic drug that cannot show it has already gone through the approval process that FDA until recently declared was neither required nor appropriate for these products.
I understand your point about requiring tests that take time to perform, but I want to be clear. You're not saying, are you, that FDA couldn't change the standards and require a new drug application, are you, for these homeopathic drugs?
Assuming that the FDA follows the normal APA process and comes to a conclusion that's supportable, of course it has the authority to do that.
Okay. So the only concern, as I understand it, you have, or the main concern, is that the alert was final agency action.
Well, that is certainly one of the grounds on which we're seeking review. The other is that the withdrawal of 400, the district court below concluded it was final agency action as well, and that the prior policy had given rise to legitimate reliance interests under the Supreme Court's decision in Regents. But then the court erroneously concluded, in our view, that the FDA had, although cursorily in the court's view, adequately analyzed whether there were reliance interests, whether they were substantial, and properly weighed them against the reliance interest at issue. And we think the court there was fundamentally wrong, that by the reasoning of the district court itself, FDA made legal errors at each one of those steps. It determined that there were no legitimate reliance interests, that there was no possibility of legitimate reliance interest because it characterized its prior policy in an inappropriate and inaccurate way. And therefore, it never determined that there was a substantial reliance interest, and it didn't meaningfully weigh them against the agency's stated reasons. The agency merely declared these are our reasons and they justify our action. That's the case. An agency has to do that in any challenge to satisfy the APA's arbitrary.
I'd really like for you to get to the issue of Cook and the letter that's at Supplemental Appendix 53, the letter of February 19th from Ms. Begley, to Ms. Begley from the FDA, and specifically redressability.
Certainly, Your Honor. So with regard to Cook, I think a few things.
Let me just say this, is that just to make clear what the concern is that I think that I have, which is that there's a final agency action here now that says that it has found these injectable homeopathic drug products to be not generally recognized as safe and effective under the Food, Drug, and Cosmetic Act. Now that that finding has been made, doesn't Cook stand for the proposition that the agency is bound by it, and that regardless of whether we were to say that the import alert and the withdrawal of the guidance were error, you can't get around this finding and the mandatory language of the statute. So you're still not going to be able to import these drugs. So that's what I want you to deal with specifically, please.
Yes, Your Honor. I'm very happy to, and I have several points to make with regard to that. The first is that I think the one thing that I think you could take away from the Cook case is that it is clear, as we've argued all along, that the issuance of the import alert itself that declares that it appears our products are unapproved new drugs was final agency action. The government's argument against that all along has been that it's merely an advisory statement and that the local field office staff can decide whether or not to follow it. And I think all the authorities we cited for that proposition already defeated that view, but Cook destroys it. Cook makes clear that once the agency has made a determination that it appears that there is an unapproved drug or some other drug that's not admissible, that it's mandatory to block it. And so that just underscores our view that from the very beginning, the import alert was final agency action. With regard to Article 3, I don't think Cook is relevant, Your Honor. Of course, it itself is not an Article 3 case. It concluded that certain enforcement discretion that was claimed by the agency in that case was not, in fact, within the agency committed to agency discretion by law, but in fact was mandated by the statute. But that case, the agency was attempting to write on a blank slate in the terms of Regents. That case was about an agency's failure to take actions required by the statute. In this case, we're not writing on a blank slate. There's longstanding policy that treated our products as if they were not new drugs and that authorized them. It was an affirmative grant of the ability to market in the United States. It wasn't even just a deference of enforcement authority, much like the DACA memo in the Regent's case. It did more than that. It provided affirmative benefits.
What I'm trying to get at, counsel, is that I understand Cook wasn't a standing case. It seems to me that Cook has significant ramifications as to whether there is redressability. So let's suppose for a moment that we completely vacate the import alert and we tell the agency that it has to reinstate the former guidance. You still are stuck with this letter at SA 53. And I don't see, given that and the finding of the agency that these don't meet the Grasset standard, how you would be redressed at all. Can you explain that, please?
Yes, absolutely, Your Honor. First of all, if the agency is required, as we think they should be, to reinstate the policy of 400, at least until they have demonstrated an appropriate consideration of the reliance interest engendered by their product, I don't think there's any plausible argument. I know the court below concluded this, but I think it's just clearly wrong, that the agency would continue to be able to detain MediNatura's products or exclude MediNatura's products. And you don't have to take my word for the fact that this enforcement priority that was reflected in the import alert is inconsistent with the policy that was established in 400. The agency itself declared that when it suddenly withdrew that policy after having promised initially to leave it in place until it was formally replaced with a new guidance. The agency, as you recall, in 2019,
that was before the agency had issued a finding that these drugs are not generally recognized as safe and effective. And if the statute is to be construed as the court did in Cook, then the FDA has no choice but to bar future importation of these drugs.
Yeah, I think that's where I think Your Honor is mistaken with regard to the implication of Cook. And I think the important thing is you have to reconcile however you may be reading Cook with what the Supreme Court said in Regents, for example. The Supreme Court in Regents was very clear that it was beside the point for purposes of reliance interest and remedy whether or not the prior policy was lawful. The primary reason it was withdrawn, the stated reason by the acting attorney general, was that it was an unlawful policy. The dissent in Regents made the point that, in fact, from Justice Thomas's dissent, so long as the agency's determination of illegality is sound, our review should be at an end. But the Supreme Court majority rejected that and said it's beside the point whether it was in fact lawful policy or not. And I'll just read this part from the opinion, Your Honor. It says that the dissent is correct that DACA was rescinded because the Attorney General's illegality determination, but nothing about that determination foreclosed or even addressed the options of retaining forbearance or accommodating particular reliance interest. The acting director should have considered those matters, but did not, and that failure was arbitrary and capricious in violation of the APA. So the fact that either before or now they think that our products are illegal does not determine whether we are entitled to have reliance interest considered, and whether or not it was arbitrary and capricious on the part of the agency to refuse to consider it. I think that, to the extent you're reading Cook, and I'm not even sure Cook supports that proposition. It's true that the agency.
Let me ask you this with respect to Cook, and I'll wait to hear Ms. Dixon's interpretation. But I find Cook irrelevant because it has to do with an unregistered establishment, and you all are registered, and the language from Judge Ginsburg about or otherwise is plainly dicta.
Well, I think that is correct, Your Honor. I think also it's very clear if you read the holding in Cook, it said, our reading of 381 does not require the FDA to inspect 21 million articles, only those that it's obligated to do so because they were manufactured at an unregistered facility. All of our products were manufactured in a registered facility. In fact, this is part of the framework of 400-400. All of our products were were manufactured in registered facilities, and the FDA routinely inspected those facilities to ensure compliance with those guidelines. Fundamentally, what we have here is a policy change on the part of the agency that said previously, because of their unique nature, and because we have not yet developed a formal GRAS-E determination process that is suited to homeopathic drugs, we have adopted this policy guidance that makes clear that if it's part of the ordinary and customary homeopathic practice, and you comply with the manufacturing requirements set out here and the labeling requirements, there's no dispute MediNatura did all of that, then you may market in the United States. And it's the import alert itself, not even the actions that followed, that for the first time and finally imposed the obligation on homeopathic drugs to satisfy the agency's current GRAS-E standards in order to import their drugs. It's the withdrawal of 400-400, and it's the imposition of the import alert that has that effect. And even if you put aside that dramatic policy change, the import alert itself seized MediNatura's products. It itself was a final agency action. Even if it's the case that additional agency actions that may be final and challengeable have occurred, that doesn't change the fact that the fundamental policy was finally determined at the time the import alert was issued with regard to that. And I would point the court to cases like Safari Club and Hawks and others that make clear that even where there's some agency action that may continue, and even where it's possible the agency might ultimately change its mind, when you have an action that is so, fundamentally affects rights as this action did, it changed the status of our products, it seized our products.
All right, Mr. Salmons, we have your argument. You're way over your time. We'll give you some time in reply, and let's hear from Ms. Dixon now.
Good morning, and may it please the court, Courtney Dixon for the government. I'll start with this question about Cook. Judge Henderson, we agree with you that Cook is not relevant here because, as Your Honor noted, Cook dealt with the agency's obligations when it's sampling from unregistered facilities. This is a registered facility. Cook was clear in its opinion that it wasn't, as it stated, exploring all of the, quote, oases of discretion that the agency might otherwise have. And we don't think the court needs to certainly weigh in on any of those questions here. Cook is doubly irrelevant here, I would say, as well, because Cook dealt with, in the unregistered facility context, the agency's obligation at the end, after it had made a final determination that the drug was unlawful, whether it needed to refuse admission or whether it might have discretion. Here, after the agency finished its process and made the final determination that MediNatura's drugs are not generally recognized as safe and effective, the agency issued refusal notices. And so the court's not confronted here with the question of what discretion FDA may have. And I don't think, again, that the court should address that, given that, again, Cook itself was careful not to wade into these questions of that weren't presented there. That said, Judge Wilkins, I do agree with perhaps maybe the instinct behind your question, which is that there is a mismatch here between what plaintiff is seeking in its preliminary injunction and the irreparable harm that it's alleging here. We think that mismatch existed even as plaintiffs before the agency had reached a final decision, because plaintiffs are challenging an import alert, which is an advisory notice to FDA field staff about this interlocutory decision about determining which drugs to detain. And of course, detention is the beginning of the administrative process and not the end. The agency has now completed that process. It's made a determination as to plaintiff's drugs, and the proper path forward is for plaintiff to amend its complaint to put those final decisions before the district court, where the full administrative record underlying the agency's decision can be produced, and plaintiffs can challenge the agency's determination that its drugs are not generally recognized as safe and effective. We think that's the reason that plaintiffs aren't entitled to a preliminary injunction, maybe not an issue of standing, given that at the time that plaintiffs filed their complaint, they had standing. But certainly, as we explained in our brief, both with respect to the guidance and with respect to the import alert, to the extent that plaintiffs are claiming that they're irreparably harmed because they can't presently market and sell their drugs, an import alert merely directed to, a preliminary injunction merely directed to the import alert or the withdrawal of FDA's guidance isn't going to allow a plaintiff to immediately begin, selling and marketing its drugs as it would like. Again, plaintiff should amend its complaint, which it has not done.
It won't allow them to, vacating the preliminary injunction won't have an effect because why?
So, Your Honor, I mean, the import alert, as I had noted, it's an advisory instruction to field staff about this interlocutory determination of which drugs do we detain pending administrative review. The agency has now reached a final decision. So adding and removing plaintiff's drugs to the import alert, that could have an effect. Maybe that would, if plaintiff's drugs are not on the import alert, that's a mechanism that FDA uses to communicate with its field staff. So arguably a future shipment of plaintiff's product, if plaintiff's drugs wasn't on the import alert, it might increase the likelihood that a drug could, fall through the cracks in the future. But again, so maybe the Article 3 standing could be satisfied. But in terms of the legal status of plaintiff's drugs and FDA's determination, the import alert, removing its products from the import alert isn't going to change that, nor will it change the fact that FDA has now made final decisions about plaintiff's products here, and that FDA can continue to detain future shipments of plaintiff's products and could continue to refuse admission to those products. Again, because the import alert is guidance to FDA field staff about this preliminary decision about which drugs to detain. It's not a final determination about the legal status of plaintiff's drugs, because again, the import alert is preliminary even to a decision whether to detain the drugs, and the detention is the start of the administrative process and not the end. With respect to the guidance, Your Honor, as the district court noted, the agency evaluated reliance interests. It explained that it had reason to withdraw its outdated 30-year-old guidance, which no longer reflected the agency's current enforcement priorities in light of recent significant safety concerns and the tremendous growth of the homeopathic drug industry in the last several decades. The agency explicitly acknowledged reliance interests. Again, it explained why those were outweighed. Plaintiffs don't dispute, of course, that the agency can change its mind about an enforcement policy that it had in place. The agency explained its reasons for doing so. Those reasons were well stated, they were well reasoned, and certainly satisfy the APA here.
So in a hypothetical situation, much as is argued here, this person's drugs were safe so far as anyone knew. They were part of a class, but there was no evidence of danger to human health. That, I gather, is not a requirement when an alert is put on, even though an alert basically can shut down your business. Is that right?
So it's not a requirement that the drug be found to be particularly dangerous. Is that Your Honor's question before it's
so it doesn't matter, even if a class of drugs is generally dangerous, but a particular supplier has a drug that is not dangerous, can he be swept up?
So, Your Honor, I guess there's a few ways of answering that question. Maybe the first being, the import alert at issue here, there's a lot of different import alerts. The specific import alert at issue here, 6641, is drugs that are suspected of being unapproved new drugs. To be
well, we know it's unapproved, all right, in the sense it's not a new drug. But is there any evidence it's dangerous? That's what I'm trying to understand, since that seems to be the standard.
The drug doesn't have to be we know that FDA has not approved plaintiff's drug, but a drug doesn't require FDA approval if it's generally recognized as safe and effective among experts qualified to recognize the safety and efficacy of drugs. So it's not simply
was there evidence here that the plaintiff's drugs were not safe? I just want to be clear.
So the FDA has, pursuant to its risk-based approach to enforcement that it's put in place, it has proceeded to enforce the FDCA's requirements against homeopathic drugs that fall into particularly risky categories. That includes—
And is this a particularly risky category?
Yes, Your Honor, because plaintiff's drugs are injectable, which means they're injected directly into the bloodstream and potentially bypass some of the body's natural defenses, and because of the ingredients that they are labeled to contain, here potentially toxic ingredients. So particularly when you have that combination, potentially toxic ingredients injected directly into the bloodstream, it does present a heightened risk. And of course, FDA added plaintiff's drugs to the import alert only when it had enough evidence to have a suspicion that, hey, these drugs, we can justify detention, and that starts the administrative process. In the administrative process, plaintiffs had the opportunity and did submit evidence to try and say, hey, our drugs are generally recognized as safe and effective among experts qualified to recognize the safety and efficacy of drugs, and that they're not new drugs. Of course, the FDA has now disagreed with that, and plaintiffs may disagree with that conclusion. But again, the proper course is for plaintiff to amend their complaint, to put FDA's final decision before the district court. The full administrative record can be introduced. So all of the evidence and arguments that plaintiff presented, the evidence and arguments the FDA relied on, all of that can be put before the district court. And again, now that the FDA has reached its final decision, that's the most appropriate path forward, rather than seeking a preliminary injunction against this preliminary advisory import alert and then FDA's withdrawal of its guidance.
Let me direct your attention to the guidance. The close issue that I see is the reliance issue, interests. And the notice in the Federal Register doesn't even mention it. And it's a pretty weighty consideration after the amount of time the guidance has been in effect. What is your best authority for answering the reliance interests coming from this citizen's petition, from a different document?
Sure. So first, the agency first announced in 2015 that it was reconsidering its guidance, and it solicited public input at that time. Right. And the agency received public input, and as part of all this consideration of its guidance, it received a citizen petition from the Americans for Homeopathic Choice that said, hey, don't rescind your guidance. In fact, you should make some, they had suggested, as they called it, modifications, but the agency said they were quite drastic changes. But the Americans for Homeopathic Choice wanted the agency to make these modifications and then codify its guidance as a regulation. And the agency, again, in the course of making this decision about its guidance, it responded to the citizen petition and said, no, we're not going to maintain our guidance. We, in fact, are going to withdraw the guidance at this time. And the agency acknowledged that the citizen's petition had explicitly invoked the longstanding nature of the guidance and reliance interests. And the agency said, you've asserted these reliance interests both on behalf of industry professionals and consumers. But the fact that the agency has determined that this guidance no longer reflects its current priorities because the homeopathic drug industry has grown significantly to $1 billion industry, which has led to an increased consumer exposures to these drugs. And that has come with a corresponding increase in safety concerns, some of which are quite significant, including infant deaths and seizures. And in the case of one homeopathic cold medicine, loss of the sense of smell. The agency recognized that its prior guidance didn't reflect its current thinking, and it wanted to move towards a more specified risk-based approach to enforcement. And so it said the agency's interests in withdrawing, again, this outdated guidance document that didn't reflect current facts before the agency, the FDA's interest in doing so in the interest of public health outweighed the asserted reliance interests. And with respect to the Federal Register notice, the agency essentially said all of those same reasons in the Federal Register notice the next day. It didn't explicitly say the words reliance interests in that Federal Register notice. But again, the same underlying points were there, and the agency, again, had responded to those reliance interests specifically where they had been invoked in the citizen petition response.
Is it basically your argument that the FDA's announcement that it was going to a risk-based approach answers the reliance interests?
I would say that the agency answered the reliance interests at the time it made its decision, and that's set forth in the citizen petition. The Federal Register notice the next day states essentially the same thing, but doesn't explicitly invoke reliance interests. But I think that that's also, again, the same reasoning is set forth there. And plaintiffs suggest that, looking at the citizen petition response, even though the words reliance interests weren't specifically included in the Federal Register notice, is, similar to a post hoc rationalization of government counsel. But the concern there is that when the agency hasn't had any discussion about something, you don't want to, take my word for it and speculate about what the agency might have been thinking. I mean, here, that's certainly not the case. We know what the agency was thinking at the time. It said it explicitly in its citizen petition response, which was a day before it published the Federal Register notice. And again, these are the words of the agency articulated at the time. So you don't have to take the words of government counsel or potentially speculate about what the agency was thinking. We know what the agency was thinking, and it set forth its reasonings clearly why, in the context of considering this exact question, whether it should withdraw or maintain its guidance.
All right. Do my colleagues have any questions of Ms. Dixon? All right, then, Mr. Salmons, why don't you take 2 minutes?
Thank you, Your Honor. I'll try to be very brief. I have just 3 quick points. The first, with regard to the import alert and the characterization that it's only advisory and doesn't have any meaningful effects, I would refer the court to the Balerno and the smoking everywhere cases and to the Cook case itself, which makes clear that that's simply not true. The import alert expressly says that it's not subject to normal discretion judgments by the local staff, and it's not merely advisory. With regard to the causal connection between the withdrawal of 400 and the issuance of the import alert and all that's followed, and to the extent that has any connection here with the remedy we're entitled to, I think it is clear on this record that the agency itself said we cannot pursue our new enforcement priorities while 400 is in place, which is the very reason it gave for why it had to withdraw it immediately. And then it, of course, immediately follows up with the import alert. To say now that those two things have no connection to one another is not plausible. If that policy is reinstated, the import alert goes down. There's no other way around it. The only basis for it was that we hadn't complied with the GRAS-E determination for pharmaceutical drugs, which of course 400 says we don't have to do. And you can't have it both ways, Your Honor. If the two things are unconnected, then they had not considered reliance interests with regard to the import alert. They need the two to be connected because the only discussion of reliance interest is in the citizen petition that they claim is connected to sufficiently to the withdrawal of 400. So they can't have it both ways. These two things are connected. And if we win that 400 has to be reinstated, then that gives us the relief we need. And then with regard to reliance, I think the Regents case is exactly on point here. What the agency says they did, what the Supreme Court required is that they assess whether there were reliance interests, determine whether they were significant, and weigh any such interest against competing policy. You look at the language that the government points to, and throughout this litigation, it's taken the position that there are no legitimate reliance interests. So therefore, there's no way they properly did the balancing that was required, and they never considered alternatives. The Supreme Court makes clear that even if the underlying policy is illegal, which you would think would give strong interest in favor of withdrawing it, that doesn't preclude them from considering forbearance, which wasn't required here, or the alternative of actually providing the homeopathic specific GRAS-E standard that they promised all along. The agency says it's barred by the statute now from doing that, even though for decades they said they had the authority and they promised to do it. By changing another policy, that can't solve the reliance interests that the Supreme Court sought to protect in Regents.
All right. Thank you, counsel. Madam Clerk, if you would call the next case.
Case number 20-5270, Judicial Watch Inc., Appellant versus Adam B. Schiff, Chairman, U.S. House Permanent Select Committee on Intelligence and U.S. House Permanent Select Committee on Intelligence. Mr. Peterson for the appellant, Mr. Tilleman for the appellees.
Mr. Peterson, good morning.
Good morning, Your Honors, and may it please the court. This case is about shedding light on unprecedented and illegitimate congressional subpoenas. The extraordinary subpoenas at issue represent a supposedly unlimited government surveillance power and an unlimited ability by Congress to, at their whim, to invade the privacy of any American. Defendants refused to release these subpoenas, seeking the private phone records of various individuals, including even a reporter. Yet all other subpoenas issued as a part of their investigation are, and this is important, are publicly available on the committee's website. But defendants refuse to release the ones that we are seeking. We believe the public has a right to know why. As a part of his investigation, Congressman Schiff secretly subpoenaed the phone records of a number of private citizens from telephone companies. He did not provide notice to these individuals in advance that their phone records were being sought. He did not subpoena the phone records directly from the citizens. Instead, he subpoenaed the phone companies for their records, preventing any opportunity for the private citizens to seek court review, as would happen in any other case in where the government is seeking this kind of information about any citizen.
Mr. Peterson, let me ask you one thing, and that is, I can't find anywhere in the record, in the online report of the Intelligence Committee, any description of the subpoena other than certain phone numbers.
Well,
is that your understanding?
Well, there's been various reporting on the issue. There's been whispers around town about what it is, from defendants' descriptions in their brief. There's at least a half dozen subpoenas that went out concerning different people to potentially different.
Now let me correct you. Concerning phone numbers, that's what I'm trying to tie down. And we don't have in the record anything that I can find other than the online report, which in footnotes gives the dates of subpoenas for phone numbers, not people. In other words, subpoena, we don't know what the subpoena said, but
right.
Is there any evidence that the subpoena said, we want Joe Blow's phone records? From what I can tell, they said, we want 803-256, blah, 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 blah.
Well, defendants have not disputed that they sought the records of individuals by name. They went to AT&T and asked for the president's lawyers, records, Rudy Giuliani, by name. They haven't disputed this. I mean, again, we haven't seen the subpoenas, and that's really part of the point here. Is we would like to see the subpoenas. That's what this is about. And I also agree that the facts have not been fully developed here. Yet the case was dismissed on a motion to dismiss, and we're here asking these questions.
So counsel is issuing the subpoena pursuant to oversight within the committee's jurisdiction on a matter within the committee's jurisdiction, a legislative act?
Usually it would be, Your Honor. Typically that's what the case law tells us. It is not always, however. I mean, there are examples, starting with Kilbourne, leading through Watkins and others, where the courts have been very careful to say that it is not an unlimited power to issue subpoenas. There are exceptions where Americans' rights have to be protected. So in this case, we believe we've more than adequately alleged that that it is not a legislative act, and therefore the speech or debate protection does not apply.
Is issuing the subpoena pursuant to an impeachment investigation a legislative act?
Again, it would depend. I mean, it would depend. And that's part of the point here of what we're trying to find out. Will any subpoena? No, I don't think that. And I don't think the court should be in a position of saying that any, for the net purposes of the next case, any subpoena is going to be fine. I mean, otherwise there will be no limit to what committee chairmen on their own volition, may go looking for. They just because they find it of interest at that moment. There has to be some restraint. There has to be some limit, and the courts up to this point have said that.
Shouldn't we look beyond the facts alleged in your complaint to make that determination? I mean, you can't just kind of plead your way around the speech and debate clause by saying something's not a legislative act.
Right. We would not. We're certainly fine with having the factual record more fully developed. I mean, that was what we're asking for, is to have this case sent back down and to have the facts fleshed out. I mean, all you have before you, Your Honors, at this point is what we believe is our well-pled allegations and statements by defendants' lawyers. That's what the record consists of. No evidence. So that is why, basically, Your Honors, we are seeking under the common law right of access these subpoenas. There is no legislative purpose to it. Speech or debate does not apply. Legislative independence is not going to be impacted by releasing these subpoenas, all the others of which have already been released on their own website. They're public records. They're official records because they were prepared, finalized, and issued to these phone companies. So in that respect, they're not the kinds of preliminary types of records that the district court received. They're final official records, and the common law right of access exists to disclose this type of information. Again, all the other subpoenas are on their website. We've more than in the public interest is served by under the common law right of access by making this kind of information available. Under defendant's theory, at a minimum, there is a factual question as to whether the subpoenas are proper. Why did they go to the phone companies and not to the individuals? Why did they do this backdoor approach? Why did they need reporters' phone calls? These are factual questions that have not been answered. There's questions of the unlimited power to invade privacy of Americans. I would like to reserve the rest of my time, going forward, unless the others have any other questions at this point.
All right, Mr. Tatelman.
Thank you, Your Honors. Good morning. Todd Tattleman for the House Permanent Select Committee on Intelligence and Chairman Schiff. As I'll start with picking up on Judge Wilkins's question, which was that plaintiffs can't plead their way around the speech or debate clause. And that has been made clear by this court on any number of occasions, most recently in the court's opinion in Rangel versus Boehner, where this court said specifically that the mere allegations of violations of House rules, federal laws, or even the Constitution is not sufficient to overcome the absolute immunity afforded by the speech or debate clause of the Constitution. That's essentially what we have here, Your Honors, is plaintiffs are alleging that because they think Mr. Schiff and the committee violated House rules, the Constitution, or other federal laws, that they're entitled to bring the committee into court and to get a court order to produce various legislative documents. That's simply exactly what the speech or debate clause was intended to prevent and protect. And the Supreme Court and this court have been very clear about that fact in virtually every case that has been decided raising the clause as a defense. Rangel versus Boehner is one of the most recent examples. Same thing in other cases, including McShirley versus McClellan, Eastland versus U.S. Servicemen's Fund, and a whole host of others that we've cited in our brief. At the end of the day, this is a case about the production of various legislative documents. The subpoenas themselves, regardless of whether all or some or even any of them have been posted on the committee's website, remain legislative documents. They remain protected by the speech or debate clause. And the plaintiff simply cannot bring the committee and its chairman into court and require a court order that we produce them. This court made clear in Brown and Williamson that the committees have a right to protect their own legislative records, and that's what the committee has chosen to do here. It has particular reasons why it chose to release the documents that it chose to release, why it included the information it included in its final report, and it has opted not to publicly release these particular subpoenas, primarily for the reason that Judge Henderson mentioned, which was that the subpoenas themselves are to third-party telecommunications companies and are seeking personally identifiable information, various phone numbers, and other types of things. So the committee has not released any of those subpoenas. It was very careful in its report not to release that kind of information. What it released was the information that it obtained making the connections between various phone numbers and individuals that it was able to make based on the information that it had obtained.
Well, let me ask you about that, Mr. Tettleman. I'm looking at page 44 of the report, just as an example. And the footnote 49, well, here's the sentence in the report. Phone records show that in the 48 hours before publication of the Hill opinion piece, Mr. Parnas spoke with Mr. Solomon. Footnote 49. Footnote 49 cites AT&T document production, and then Bates and ATT, and then the committee's initials. And I read the next figure to be the date that it issued. That is September 19th, 2019, or September 30th, 2019.
Yes, Your Honor, I believe that is correct.
All right. So you've identified, when you say you haven't identified in the report the subpoena, you have at least identified who it went to, AT&T, and the date it went.
That is correct, Your Honor. The wording there, I think, was very deliberately chosen by the committee. Again, what the committee was doing at the time was it was engaged in a full-fledged both oversight investigation, as Judge Wilkins mentioned, as well as an impeachment inquiry, as the Speaker of the House made clear several days earlier on September 24th.
Well, I'd like to ask you about that, because the impeachment resolution didn't come until October 31st.
The resolution that was adopted by the House, correct, Judge Henderson, HRS 660 doesn't come until October, but that's not, in fact, an impeachment resolution in, I believe, the sense that you're thinking of it as. What that was a procedural resolution that allowed certain procedures by the committees that followed it to occur. There doesn't need to be, under House precedent and practice, an impeachment resolution prior to an investigation or an inquiry into impeachment beginning, and there wasn't in this case. HRS 660 laid out for the Committee on Intelligence some requirements about how it was to go about holding public hearings, and it also required the committee to produce the report that it eventually produced, recommending to the Judiciary Committee whether or not the Judiciary Committee should draft and approve articles of impeachment. HRES 660 set out for the House and for the committees those procedures that it was to follow from that point forward. But the inquiry underlying that, the impeachment inquiry and the oversight related to the intelligence community, the whistleblower, and the activities going on in Ukraine were all well established, predated that in resolution, and were well within the committee's jurisdiction at the time it issued this particular subpoena. But
so so you're not relying on the speaker's, I guess, announcement in early September that the committees are to proceed?
No, Your Honor, I believe we're doing both, which is to say we believe that both parts of the Gravel test related to whether speech or debate are applicable were satisfied here. First of all, the underlying oversight and an investigation that had been taking place prior to the speaker's announcement satisfied the first part of the Gravel test because they are an integral part of the deliberative and communicative process of the House. And then the second part of the test, which is the part related to the impeachment inquiry, because impeachment is a matter specifically delegated by the Constitution to the House, is also satisfied. So we are in fact relying on both. So even if you were to find that the impeachment inquiry was entirely based on the resolution that comes later, we don't think that changes the ultimate outcome here because the underlying investigation that was ongoing as of September 30th when this particular subpoena was issued was a legitimate legislative act. There was a legitimate legislative purpose and all of the other requirements are satisfied. So in that sense, we're relying on both. But for a moment, if I can go back, Judge Henderson, to talking about the language in the report about the phone record, the subpoena and the phone records, what the committee was doing at the time was it was interviewing witnesses, conducting depositions, and reviewing materials that people were providing to it, even though the administration at the time was not allowing any official records to come forward. So as the committee was taking people's depositions and acquiring information through oral recollections and people's best memories, they were left with several significant gaps as to what people couldn't remember, as to what people thought might have happened. A witness might have said that they thought that they took a phone call from a particular individual at a particular time, but since they hadn't been given access to their records, they weren't able to state that. So what the committee was doing was using the phone record subpoenas to fill in the gaps from the information that it had. And that was its purpose. Its purpose was not to invade the privacy of the individuals. It was simply to corroborate and fill those gaps that it was getting from the oral recollections of the witnesses and the other documents that it was obtaining. So there is no question here in our mind that the subpoenas satisfy the legitimate legislative purpose test. But as we said at the outset, that's really not of any significance here because what's going on here is Judicial Watch's attempt to bring the plaintiff, to bring the committee and the chairman before the court in a manner that it's simply not permitted to do. Cases, the mere fact that Judicial Watch is asking for the case to be remanded so that further factual developments can be had is itself what the clause was intended to protect against. And what this court has said on numerous occasions is that the clause protects the House and its committees and its members from having to do, which is to defend itself in litigation, defend itself from having civil suits brought against it, and ultimately here to defend itself from having court-ordered production of documents that it simply has already made its own decision not to release to the public.
So is there any limitation to this principle then? Can a subpoena be issued for any information and that can't be beyond the scope of the speech and debate clause protection?
No, Your Honor, I don't think there is any subpoena that cannot be beyond the scope. The question is sort of how does that question come before the court? Had in certain instances, and we've seen this in the past, had one of the telecommunications companies challenged the validity of the subpoena or sought to refuse producing the records, there could have been, contempt proceedings, which is how Kilbourne and Wilkins, the cases that Mr. Peterson cited, came before the court. Had AT&T refused to produce the subpoenas, the committee could have attempted to bring an enforcement action to this court against AT&T that would have allowed this court to review and adjudicate that question. What we do know for certain is that the question can't be brought before the court in the manner that it's being brought before it here, which is as a suit against the committees, and certainly as a suit here under the common law right of access, which clearly doesn't apply to these particular documents because the constitutional privilege precludes the application of that common law right.
Now, what's your authority for what you just said? I have not found any case that upholds the speech or debate clause immunity with regard to the common law right of access.
Your Honor, I don't believe that there is a case that holds that because there haven't been cases litigated against Congress for the common as applying for the common law right of action in this court. There was the Pentagen case in the lower court, which found that those records were not applicable to the common law right of access and protected by the speech or debate clause. And then there was...
Well, that's because they weren't public records. If we get through the first prong, that these subpoenas are in fact public records, then the second prong requires balancing the right of the public to know things versus whatever the governmental right is, which in this case is the speech or debate. I don't think that question has ever been raised before.
I am unaware of a case that raises that question as well, Judge Henderson, and we think not only can you not actually get past the speech or debate immunity in this case, but even if for some reason you concluded that you could, I don't think that the subpoenas in question here, for the reasons that we discussed in our papers, that the plaintiffs have satisfied the common law right of access standard. The subpoenas themselves don't meet the definition of a public record as the court has defined it in this instance. And so we don't think that even if you could get that far, which we don't think
Let's say you can. Let's say they're public records. What about the second prong?
Certainly, Your Honor. I think the second prong, you hinted at it earlier, the interest that needs to, the two interests that the committee that needs to be protected. One is, making sure that its investigative sources and methods and its decisions about its investigative process would need to be protected. But also there's likely to be substantial privacy interests on the part of the many people whose phone numbers may have been sought as part of this inquiry. So releasing that information would expose those personal details and might actually, cause more damage than what the committee has, very carefully elected to make public and what it has not. So I don't think that those interests are outweighed by the claims by the plaintiffs that there's this general right to know. The report makes it very clear exactly what the committee did and lays out its evidence that it used to rely upon and to recommend to the Judiciary Committee that articles of impeachment be drafted. As you well know, those articles were drafted, approved by the court, and tried by the Senate. So I don't know that there's much of an interest beyond what's already been publicly released.
Well, I do think it's, if not ironic, noteworthy that one of the interests you've just put forward is the invasion of privacy, when the whole claim of Judicial Watch is that this committee invaded the privacy of private citizens in the first place.
Your Honor, I think that the committee was very careful to not only draft its subpoenas in as narrow a way as possible, but also to only release the information that was relevant to its inquiry. As in every inquiry of this type, the committee receives a tremendous amount of information that ends up being responsive to its subpoenas, but not ultimately relevant to the questions before it. The committee was careful in describing the evidence that was relevant to it. I don't believe that is the entirety of everything that the committee received, or even the entirety of everything the committee asked for in its subpoenas. So while we would submit that there very likely were information sought and received by the committee that ended up not being particularly relevant or not useful to its inquiry, that would be the type of information that shouldn't be further released and that further release would do damage to. Certainly there were people's information that was released and discussed in the report and obtained by the committee. We don't deny that. But we think that the committee carefully made that determination on its own. That determination is to be respected and should be not second guessed or overturned by plaintiffs' mere allegations, and is subject to, among other things, a presumption of regularity that the committee should be afforded and deferred to.
Okay. Do my colleagues have any questions of Mr. Tatelman? All right. Then, Mr. Peterson, I don't know how much time you reserved, but take 2 minutes. All right. That's Mr. Peterson.
Yes, thank you, Your Honor. We're having issues with the mute button there. Well, Mr. Tatelman just expressed in terms of whether or not the power is unlimited and unreviewable was extraordinarily revealing. He stated openly that, well, the telecommunications companies could have challenged the subpoena, and they didn't, apparently. We don't know for sure. But that is precisely the point. They went behind the individuals' backs, and instead of going to the individuals for the phone records, they went to the telecommunications companies, which are highly regulated by the government, beholden to Congress, and of course they rolled over, and these individuals' rights were violated without any opportunity for a judicial review. That is exactly why there needs to be not this unlimited power on behalf of Congress. And that is why there's a very real question here of whether it's a legitimate legislative act. And the 2015 decision in Rangel from that Judge Henderson authored, that was a very different case. I mean, that had involved a challenge to a censure. As we've just heard, this is a common law right of access case. We don't need Judicial Watch does not need to be the victim of improper behavior to bring this challenge, just as in FOIA, a party doesn't have to, by analogy, but doesn't have to be the victim of government misconduct to bring the FOIA request. The public has a right to know under the common law right of access, a right that has been consistently withheld by the Supreme Court in this court to learn what is going on. Mr. Tatelman said repeatedly all the different things that they got, but they haven't released and otherwise. Well, again, that is precisely the point. We need to learn more. We need to understand, because very serious matters happen here: invasions of privacy, violations of rights, behavior by this committee. It is not an unlimited power, and it cannot be an unlimited power, or the next time the consequences will be very, very serious.
All right, Mr. Peterson, thank you. If my colleagues have no questions, then the case is submitted.
Thank you, Your Honors.
The Honorable Court is now adjourned until Friday, March 26th at 9:30 a.m.